Welcome to this explainer. Today we are completely unpacking the concept of bail under the Criminal Procedure Code, or the CrPC. We're going to cut right through the dense legal jargon of our source lecture to figure out exactly how the justice system tries to balance individual freedom with societal safety. And right off the bat, we're going to see why bail is fundamentally about the right to liberty, and absolutely not meant to be a pretrial punishment.
To do this, we'll be using this really fantastic visual map from our source material. We're taking these complex statutory provisions and turning them into a clear, human-centric story. So instead of just staring at walls of complicated legal text, we can actually track the entire journey of the bail process, going from its underlying philosophy all the way to how it works in the real world.
Here's our quick roadmap for today. First, understanding what bail actually means for personal liberty. Second, the 4 types of bail. Third, the step-by-step process. Fourth, how judges grant or reject it. And finally, the rights and rules involved.
All right, let's jump straight into Section 1, Understanding Bail and Liberty.
Okay, if you take away only one thing from this explainer, make it this. Bail is the rule, jail is an exception. This is literally known as the golden rule of the criminal justice system. But why? Why is it the rule? Well, it's rooted in 2 massive constitutional principles. First up is the presumption of innocence under Article 10A of the Constitution. Basically, you are innocent until proven guilty. Second, personal liberty is a fundamental right under Article 9. So because you're presumed innocent, locking you up before a trial is even finished should really only happen in exceptional circumstances. The court always has to balance the rights of the accused with the broader interest of justice.
So, legally speaking, what is it? Our source defines bail as the temporary release of an accused person from custody on a bond and sureties with a promise to appear before the court when required. But in everyday language, it's a promise. It means you're free for now, but you absolutely must come to court whenever called. It's a trade-off, really. You are securing your physical freedom by guaranteeing your strict legal compliance.
Which brings us to Section 2, the 4 types of bail.
Totally matters here because not all bail is the same thing. The Criminal Procedure Code actually lays out 4 distinct types. First, you've got regular bail under Section 498, which is what you'd apply for after an arrest has happened. Second is pre-arrest bail under Section 498A. Now this one is fascinating. If you legitimately anticipate or apprehend that you're going to be arrested, you can actually apply for this before the police take you into custody. Third is interim or transit bail, which is just a temporary bail granted for a very short, specific window of time. And fourth is default bail under Section 497. This kicks in if the police fail to complete their investigation within the required time limit. If they drag their feet and take too long, the accused actually earns a statutory right to be released.
And guys, this requires a huge mindset shift. Bail is not a favor. It is your right when the law allows for it. Getting one of these types of bail isn't about begging a judge for some special kindness. When the legal conditions are met, releasing the accused is simply a procedural right.
Let's look at how this works in practice in Section 3, the step-by-step process.
Let's bring this to life with a real-world example from our source material. Imagine a guy named Ali who gets arrested in a theft case. Step 1, the police arrest Ali. But they can't just throw him in a cell and forget about him. The law strictly requires them to produce him before a magistrate within 24 hours. Step 2, Ali or his lawyer files a formal bail application to the court. Step 3 is the all-important bail hearing. And the court doesn't just listen to Ali here, it hears arguments from both sides, the prosecution, who probably wants to keep him in jail, and the defense, arguing for his release. Finally, Step 4, if the court is satisfied, it issues an approved bail order. Ali's side then furnishes the required surety and bail bonds, and he's released, promising to show up on his next court date.
But how do they actually make that choice? That's Section 4, granting or rejecting bail.
Judges have to perform a really careful balancing act to decide whether to let Ali go or keep him locked up. On one hand, they weigh factors like the exact nature and gravity of the offense, the specific role the accused played, and their past criminal record. But on the flip side, bail can and will be explicitly rejected if the risk is just too high. We're talking about situations where the offense is exceptionally serious, or if there's a huge risk the accused will just abscond, flee the country. They'll also reject it if the accused might tamper with evidence, threaten witnesses, or if releasing them would totally derail the ongoing investigation. It's a very precise, very serious calculation of risk versus liberty.
And finally, Section 5, Rights, Conditions, and Rules.
So let's say bail is granted. That does not mean the accused is completely off the hook. Freedom on bail is strictly conditional. The court is going to impose firm rules to make sure the justice process stays on track.
The accused has to appear in court on every single required date, no exceptions. They cannot leave the country without explicit permission. They are strictly forbidden from tampering with evidence or trying to intimidate witnesses. Plus, they literally have to actively assist in the ongoing police investigation. If you break even one of these rules, your bail can be revoked immediately. Back to jail?
But conversely, the accused has very specific rights in this process too. They have the absolute right to be released if the law allows it. They have a right to a fair hearing. They have the right to furnish a surety or bond as per the law. And, this is crucial, if bail is rejected, they have the right to know the exact reasons why. They aren't just left in the dark. And lastly, they have the right to apply again later if new facts emerge in the case.
Okay, so what's the actual legal scaffolding holding all this up? Well, it's governed by some very specific sections in the CrPC that map out exactly who has the power to do what. Section 437 deals with bail and bailable offenses, which is generally handled by a magistrate. Section 439 covers non-bailable offenses, handled by magistrates and sessions courts. Then there's Section 436A, which is super progressive. It actually allows for bail if an under trial has already spent half of the maximum possible punishment for their alleged crime sitting behind bars. And like we talked about earlier, Section 497 governs default bail, while Sections 498 and 498A govern the rules for pre-arrest bail, which are often handled by higher courts.
All right, let's wrap up this explainer by testing what we've learned with a quick quiz right from our source material. Do you remember? Under which section is default bail granted when an investigation isn't completed in time? Is it A, 437, B, 497, C, 498, or D, 439? Think about it for a second. The answer is B, Section 497. You know, understanding these rules isn't just about memorizing old laws. It's really about understanding how a society actively safeguards human freedom. So I'll leave you with this thought. The next time you look at the news and see a high-profile arrest, ask yourself, is the system truly treating jail as the exception, or do we still have work to do to protect personal liberty? Thanks for joining me on this explainer, and keep questioning the world around you.